All right, okay, hi everyone. Welcome to today's Southernising Criminology discussion group event. I'm Luis Del Santo. I'm here with my fellow ZIFU student Lucy Harry, and we are thrilled to have you all here this afternoon for the final event of this academic year. So we're delighted to be hosting Dr. Ali Wardak of the University of South Wales. He will be presenting on the topic of contributions from South Asia, a hybrid model of formal and informal justice in Afghanistan. So he will provide a general overview of the state of criminology in South Asia, and in particular reflect upon the dominance of informal models of justice, before moving on to discuss findings from his award-winning research on Afghanistan's justice system. Before I hand over to Lucy to introduce today's speaker, I just want to say a few words about our discussion group. We are a student-led initiative who aim to facilitate discussions about criminology, moving away from the hegemonic Western paradigm to then encompass some perspectives from the global South. And this term, we have focused on criminological contributions from different geographical regions. In the next term, we'll be focused on methodological and philosophical challenges and opportunities in Southernising criminology. We will be posting our term card shortly, so please look out for that. Today, Professor Wardak will present for about half an hour or so, and then this will be followed by a Q&A session. So could I ask you to please mute yourself during his presentation, and then raise your hand or put a question into the chat box during the discussion section. So just to let you know, we'll be recording Dr. Wardak's presentation, but we'll stop recording during the Q&A session. And I think that's all from me. Now hand over to Lucy to formally introduce today's speaker.
Thank you. So Professor Ali Wardak obtained his PhD from the University of Edinburgh and teaches criminology at the University of South Wales, where he is also a fellow of the UK's Higher Education Academy and the Vice President of the South Asian Society of Criminology and Victimology. His main teaching and research interests focus on comparative crime and justice, transnational crime, restorative justice, and the relationships between state and non-state justice systems. From 2006 to 2008, he worked for the UN Development Programme in Kabul, where he co-authored the 2007 Afghanistan Human Development Report, where a hybrid model for a post-Taliban justice system in Afghanistan was proposed. He has also worked with Professor John Braithwaite of the ANU on a research project that focuses on what works in peacebuilding and on the causes of conflict in 28 countries around the world, for which they received the 2013 Radanal-Switz Prize. And on winning this prestigious prize, Professor Wardak was congratulated by President Ashraf Ghani of Afghanistan through an official letter of tributes. In November 2017, he also won the University of South Wales Best International Impact Award in recognition of his research on the justice system of Afghanistan, and his research was also nominated for the 2018 Times Higher Education Awards. We're absolutely delighted to be hosting you today, Professor Wardak, and I will hand over to you now.
Thank you very much, Lucy and Louise, for this kind introduction, and also for inviting me to speak at this important forum. In fact, also it is important to mention that it was through your forum that I could reconnect with my former classmates, Biko Agazino and Yin Loda. The three of us were Garland's students at Edinburgh University and PhD students later. So I'm really very pleased to be with you here, and good evening, everyone. Let me share my slides with you. Okay, as you could see from the screen, I'll be speaking about contribution to the Southernising Criminology series of talks, but the focus of my talk will be on the hybrid model of formal and informal justice in Afghanistan. Just to provide you with a roadmap of my 30 minutes talk. First of all, I'll be briefly speaking about the state of criminology in South Asia. I'll be making some generalizations, but very briefly. Then I'll be looking at the Afghan justice system, and especially the efforts to rebuild it in the past 20 years. Then I'll be looking at the prevalence of informal justice in Afghanistan and its weaknesses and strengths. Then I will go and look at the hybrid model of justice system that I will illustrate in a diagram. And finally, the impact of the hybrid model and also its contribution towards Southernising criminology. So first, South Asian criminology. In fact, the phrase South Asian criminology mainly refers to differing forms of criminological knowledge that have developed in different countries in South Asia. So this means that there doesn't exist really a coherent body of criminological knowledge that could be called, strictly speaking, as South Asian criminology. One of the main reasons for this is the lack of dialogue and effective collaboration among countries and scholars in this region. But also it's important to mention that it is difficult to define what South Asia is. For example, Afghanistan is included in South Asia, but in reality, Afghanistan is a crossroad between Central Asia, South Asia, and the Middle East. So there are different influences, cultural influences and legal influences. Also, although Afghanistan is connected, there is a South Asian influence, but the legal system of Afghanistan is mainly influenced by the French conception of legality rather than by the British colonial justice system, as is the case in the rest of the South Asian countries. So the existing body of criminological knowledge in much of South Asia, especially in India, Bangladesh, and Pakistan, is strongly influenced by criminological thinking and practices in the global north, mainly by criminological thinking in the United States and in the UK. Nevertheless, there have been some important developments in recent years. For example, the regular publication of the International Journal of Criminal Justice Sciences in India and the Pakistan Journal of Criminology, but also the more recent publication last year, actually, of the Routledge Handbook of South Asian Criminology have contributed to the dissemination and publication of more indigenous research that are conducted in the region. And I feel privileged to be on the editorial board of both the journal, but also contributed 2 chapters to the Handbook of South Asian Criminology. Also, there is must mention there is an annual conference in India. Of course, this happened before the COVID-19 situation, that brought scholars from different parts of the world, which discussed and examined various criminological topics and issues. But even that conference was very much influenced by criminological thinking in the global north. So despite these recent developments, the three developments I just mentioned, there is still a long way for an indigenous criminological perspective or perspectives to emerge in this region. So there is really there are no indigenous criminological or penological perspectives that could be called South Asian. Some of the main reasons for the absence of independent or indigenous criminological perspectives in South Asia are colonial legacies. When I say colonial legacies, the justice system in much of South Asia, especially in India, Bangladesh, and Pakistan, are based on the imperial British justice system. In fact, the British system has moved on, it has evolved, it has changed. But the justice system in these three countries, and also beyond in some of the other South Asian countries, they represent to me some as bad photocopies of the British imperial system. By this I mean they are highly bureaucratic, highly elitist, and also very corrupt and politicized. And of course, that kind of justice system doesn't allow for a change. It doesn't support research because it doesn't intend to change. There is no people who control the justice system, the states. They use them for political purposes. They use the justice system for political purposes, and they don't want reform or change. Or if there is reform, that reform mainly serves interests of the politically powerful. But also the other reason for the lack of indigenous perspectives in South Asia is the lack of collaboration among criminological scholars in the region, but also the lack of confidence, because most criminologists in the South Asian region are trained and educated in the West, and they have, if you like, imported Western perspectives. They use them as theoretical frameworks, as methodologies, and reproduce the kind of research that were produced, or the theories that were developed 60, 70 years ago, especially in the United States and in the UK. But also the lack of financial resources, or the lack of strong financial resources. You know, the kind of financial support that we have in the UK and beyond the United States, this really doesn't exist. In fact, when academics get funds, those funds are also have specific objectives. They want the researchers to produce the kind of research that the institutions or the funding agency want them to produce. So that really is not research. Despite all this, the research I conducted in Afghanistan, and in my view, the hybrid model, it represents a small contribution towards the Southernisation of criminological region in Afghanistan and in the region. And I will discuss this in the next slide. Sorry, in the main part of my my presentation. So, before I go to the actual to examining the hybrid model of the justice system in Afghanistan, it's important to briefly provide a background to the justice system in Afghanistan and its post-Taliban rebuilding. As most of you are familiar, in 1979, the Soviet Union invaded Afghanistan, and then a long war, it's now almost 42 years, has really destroyed much of the justice system and other institutions in the country. That included both justice officials, facilities, buildings, laws, and the justice system that was mainly based on the French conception of legality and Islamic jurisprudence didn't exist after the Taliban were gone in 2001. So much of the world, especially the Western world, poured money and started rebuilding Afghanistan's political, cultural, economic, but also justice institutions. There are so many countries. There have been so many countries involved in the rebuilding of the justice system, including the UK, Italy, Germany, the United Nations, and of course the USA. We don't know how much money is spent, but the USA in 2015, it's one of its institution, Congress-funded institutions, said that until 2015, the United States alone spent $1 billion on rebuilding the Afghanistan justice state institutions or the justice sector. So you can imagine, you know, already the 5 or 6 years have gone, and those spending, of course, at a lower level, have been continuing and still continue. But also, if you look at the spending or the money that have been spent on the rebuilding of the justice system by other countries, the United Nations, I'm confident that about $2 billion have been spent on the rebuilding of the justice system. Of course, this investment has resulted in some tangible achievements. For example, capacity building and professional training of justice officials, judges, prosecutors, police officers, the physical reconstruction and refurbishment of many key justice institutions and facilities that were destroyed by the war, legislation, legal reform, with special emphasis on human rights, human and women rights. So and the dissemination and publication of laws. So the achievements are quite tangible. But the irony is that despite all this huge investment, probably $2 billion, the state justice system still fails to provide effective justice to all Afghans. There is widespread corruption and people don't trust it. And as a result, most Afghans, when I say most, you know, when I conducted the research in 2007, there were about 80% of the people, they took their disputes and or criminal cases, offenses were referred to non-state justice institutions. Other research generally supported our figures. Some say 75, some say 90 even. So it is mainly the non-state justice institutions or informal justice institutions that have been dealing with both offenses and civil disputes. And this situation continues despite the investment that have been made in the past 20 years in the rebuilding of the justice system. But what are the main justice providers in Afghanistan? In my research in 2014, I was myself shocked to see that there was more than 2 or 3 main justice providers that provided justice before I conducted the research. In other words, in 2007 and 6, when I conducted research for the UNDP and for the Afghanistan Human Development Report, the main informal justice institutions were Jirga, Anshura, and some religious institutions. But in 2016, when I looked at the institutions that provided justice to the Afghan people, I was shocked that there were, you know, a dozen of formal, semi-formal, and informal institutions that were in some or another, one or another way involved in the resolution of disputes and the provision of justice. I'll just, if you look at this diagram, I ranked, if you like, or ordered these justice providers on the level of their formality. Of course, the state justice system I've just mentioned, which is based on positive law, mainly on the French legal system and on Islamic jurisprudence, but only about 20 to 30% of the people use that justice system, so it's an underused justice system. But more in this case means the Ministry of Women Affairs, and Afghanistan, and the AIHRC means Afghanistan Independent Human Rights Commission. The first one, MOA, the Ministry of Women Affairs, it is a ministry, it is a government institutions, but it's not a state justice institutions. And yet it was involved in the resolution of disputes between, especially when the case was related to domestic violence. So in other words, for example, when husband and wife had a dispute, instead of going to the state justice system, they went to the director of women affairs in the provincial center, and they resolved the disputes in an amicable way. But still, it is a formal institution. It is part of the state of Afghanistan, but it is not part of the justice system. Very similar situation with Afghanistan Independent Human Rights Commission. It is a state-sponsored institution, which basically is there to monitor human rights violations and protect human rights. But it did a very similar job. Then there were, but these two, I mean, the complexity of the justice provider is these two are state institutions, but they are not justice institutions, and yet they provided justice. Then there were international NGOs with huge resources, both human and financial, very well trained, mainly female lawyers and advocates and aid providers. They were involved in the resolution of disputes and in providing aid to disputants. Excuse me. Then there were, excuse me, there were national NGOs, local NGOs who also provided, were involved in the resolution of disputes and in providing legal aid to disputants and to victims and offenders. In cities, there were, in Farsi, in Dari, it's called Wakil Guzars. These are selected, if you like, representatives of urban neighborhoods who were also involved in dispute resolution, but almost totally informal. But the fact that the majority of Afghan lives in rural areas, Jirga and Shura were the most dominant institutions that provided justice completely outside the state justice, or mainly outside the state justice system, and in very informal way. I will discuss this later. Jirga basically are community village elders who may be illiterate, but they have a reputation of being honest and reputation and with proven skills of dispute resolution, and also the power, social power, to enforce their decision. Then there were religious institutions and ulama who also were involved in the resolution of disputes. In fact, I mentioned earlier, you know, much Afghanistan civil law is mainly based on Islamic jurisprudence. And because these religious leaders were expert in religious in Islamic law, so their decisions were very close to the way that a state court would resolve a disputes. But of course, the religious institution resolved these disputes amicably and quickly, speedily. And then there was the Taliban justice and mobile courts. In some areas that were under the control of the Taliban provided their own justice. But in fact, in some areas, people who could not receive justice from, for example, urban Wakil Guzar, so there is also a reputation, there is some corruption among Wakil Guzars. They would go to the Taliban court for the resolution of their disputes. So you could see that there is multiplicity of justice providers. But the key point here is, you know, the more informal the justice provider is, the more popular it is, because the informality means flexibility. Informality means accessibility. Informality also means cost effectiveness. You don't have to fill forms or go through procedures. And now, let's look at what are the strengths and weaknesses of informal justice providers. Well, first of all, informal justice institutions are more accessible. Every village has Jirga and Shura, and they're cost effective because you don't have to fill forms. You don't need to provide to travel somewhere or stay in a hotel. More importantly, they're peacemaking. They emphasize on peacemaking and restorative justice. You know, they are not there to punish people. They want to reconcile and make peace and reintegrate offenders back into the community. They're more flexible. You can go there at night, in the evening. People could sit under a tree or in a school, in someone's house. They're speedy. They could resolve an issue in a matter of days, sometimes in 2-3 days. Community ownership. You know, I mentioned earlier, you know, the justice institutions in much of South Asia are elitist. Here, people, local elders who have local knowledge, they resolve disputes based on what is actually happening. Relative transparency. I mentioned earlier when the state justice institutions are really thoroughly corrupt, but informal institutions, there is some corruption, but they're more transparent and less corrupt. Confidentiality and protection of women and children rights. In Afghanistan, when you go to state court, you need witnesses, you need many people are illiterate, and you need someone to fill the forms. And when you go to the town, everybody knows what has happened. But if you go to a village elders in the evening, no one would see you. And those elders, because people trust them, you know, an issue is resolved amicably. However, this really, I think I portrayed a rosy picture. This is not so straightforward. The state justice, the informal justice institution, most of them, they exclude women. They are men-only institutions. There are some cases where women are also involved in dispute resolution, but generally these are men-only institutions. And therefore, occasional violation of human rights and Afghan law take place. But also because of the long history of war in Afghanistan, there are some local strongmen who influence the decision. But more importantly, the decisions that are made by informal justice providers, they're not officially recognized, they're not binding legally, although they're binding, if you like, socially and morally. The elders could enforce the decisions through informal tools, if you like. Also, there is more emphasis on community harmony than on individual rights. That means that you know what is the elders focus on how to integrate offender back into the community, how to reconcile the victim and the offender, how to resolve the disputes, rather than individual rights, especially when there are children involved. Now, the key question is what to do with institutions that are so prevalent. They have some really negative aspects, but they also have positive aspects. There have been 4 policy options that I have been discussing, or I discussed, especially when I was conducting the research in 2006 and 7 in Afghanistan. And these were the key policy options that were discussed between me and justice officials, human rights advocates, but also government officials. Abolition, just to completely abolish them. And this was the position of some of the human rights advocates. They say, well, the non-state justice institutions, especially Jirga and Shura, are inherently anti-women, and then they should be abolished. On the other hand, state justice officials and state officials, they say, well, no, informal justice institutions are important, but they should come under the strict control of the state justice system. In other words, they should become part and parcel of the state justice system. But the key question was, if informal justice get integrated in the state justice system, then it is no more informal. The third option was reform. what kind of reform? A reform to multi-agency engagement that allows informal justice institutions continue to develop while seeking means to promote their orderly administration, gender equality, monitoring illegitimate influences of, for example, of local strongmen and violation of Afghan law, children's and human rights. So this means that let the non-state justice institutions continue because they are an integral part of society. They are organic, but let's reform them in such a way that violations don't take place. And the fourth option was non-interference. Some, again, human rights advocates say that, well, yeah, these institutions are a reality on the ground, but let's not reform them and let's do nothing with them. But the key question was then human rights violation will take place. So there was so much opposition to my work to the hybrid model, which came in option 3. My position was option 3, but I was bombarded by really the very conservative Afghan judiciary, but also very strangely by human rights advocates and lawyers that were very much product of the global north. So, I developed my ideas and developed the hybrid model to which I will come. But let's very quickly look at what legal hybridity means. Of course, there are long discussions about what legal hybridity is, but I just prefer to use Mary's description, which she says that it is closely connected with legal pluralism, which is a situation in which two or more legal systems coexist in the same social fields. And here, the phrase legal system means informal law-like systems that coexist alongside with the state legal system. You know, I've just mentioned in the multiplicity of justice providers that there are various justice providers that coexist. Of course, the existence is not smooth. It is problematic, no doubt. And when the coexistence of legal system is not formally defined or problematic, then there is need for institutionalized hybridization of the legal systems. In fact, Forsyth from Australian National University, she has illustrated the various countries which have engaged with informal justice systems, and she says that there are some countries who have integrated informal justice institutions into their legal systems. Others abolished them, and still others have found, some other mechanism for linking state and non-state justice institutions. She provided, I think, 6 or 7 models. But what the hybrid model of state and non-state justice system, or a formal and informal justice system in Afghanistan, mean and how it looks like? This diagram actually sums up, the hybrid model I developed for the Afghanistan Human Development Report in 2007. It may look complicated, but just look at the boxes, which shows human rights violation incidents, serious criminal incidents, major civil disputes, minor civil disputes, and criminal incidents. Let's look at the slides, which is almost in the middle, serious criminal incidents. My proposal was that, of course, serious criminal incidents such as murder, which was complex usually, or, for example, serious sexual offenses, or robbery, or terrorism, they should stay as a monopoly. The state should have a monopoly on dealing with those incidents. The main reason was because Afghanistan is still emerging from the ashes of war, and through the application of formal law, the state exercises its own authority. So it is important that the state exercise complete authority and deal with serious offenses. I don't want the details, but the serious offenses are defined in Afghan criminal law. But if you go to the right-hand side, major civil disputes, well, major civil disputes are huge business disputes if it's not complex. people could go to the state justice system. You can see the Minister of Justice Hukuk Department, this is the Rights Department, go to the State Court of Justice, and then they resolve that issue. But also, if people want, they should have the option to go to, on the right-hand side, the ADR, that means Alternative Dispute Resolution Unit. That includes JIRGAs, community development councils, or other civil society institutions to resolve the disputes, provided, if you look at the arrow that goes to the left-hand side, provided that there is a human rights oversight. That means that, you know, in Afghanistan, we have Afghanistan Human Rights Commission that I mentioned earlier. We have many other civil society institutions that are there to protect women and children rights. If they agree with the decision that is made by JIRGAs and Shura, it does not violate women's right, then that decision should be legally binding and be recorded at the nearest court of justice. However, if one of the parties of the disputes are dissatisfied, of course the state justice system is there. They could go there. If you go again to the very right box on the top, minor civil disputes and criminal incidents, I propose that they should not go to the state justice system. As I mentioned earlier, state justice is corrupt. It involves long delays, and it is retributive. They should go straight to the, if you like, alternative dispute resolution units or JIRGAs and Shura. But there, the decision of JIRGA and Shura must be monitored by human rights oversight, or when I say human rights oversight, these are civil society institutions that already exist. They're not parallel institutions. I'm not proposing that new institutions should be created. They already exist. And what is more important is these human rights institutions, they were mainly staffed by women. And the fact that women have more dominant role in the human rights institution, that could counterbalance the dominance of men in the ADR institutions, in JIRGA Shura. Remember, I did say that, you know, these are the JIRGA and Shura is mainly dominated by men. And if the two agree on an outcome of a dispute or a minor offense and there is no violations, that should go to the nearest court of justice and be registered. And in other words, the outcome should be as legally binding as if it was resolved, as if it was dealt with by the state court. Just finally, the left-hand side, the very left-hand side box on the left-hand side, human rights violation incidents. In the past 40 years, there have been massive human rights violations in Afghanistan, but because of impunity, because of the weak justice system, because of the influence of criminals, basically, over the state institutions, I propose that the violation of human rights, and including violence against women, this should go to human rights institutions. And in order to make them more to gain more community ownership for those resolutions or support from the human rights from the community, it maybe is a good idea also to not require, but it could also go to the ADR to communicate how to resolve a dispute, for example, between husband and wife. And if the outcome was satisfactory to both victim and offender, it doesn't have to go to the state court for a registration. It could stop there and the issue would be resolved. But if it needs to be resolved or it needs to be recorded, then it could go to the Court of Justice. However, if these are serious and really sensitive issues, if one of the parties were not happy with the outcome, of course, the state justice is still there. It could go back to the police and to the prosecution, and it could go to the Court of Justice. I will finish it in 5 minutes. So now, what is the impact of this, the hybrid model? What were the challenges in putting it into practice? Because I have just 30 minutes, I didn't mention that the 2007 Afghanistan Human Development Report, where the hybrid model was proposed, was banned by the Supreme Court, actually. In fact, I was summoned by the Supreme Court and very close to be prosecuted. It's a long story. I don't want to give the details. But then in 2014, I was invited again to do some more research, focus only on the links between formal and informal justice institutions that relates to civil matters, but not to criminal matters. Because the human rights defenders and advocates, they say criminal matters should stay as a monopoly of the state. I disagree with them, but then in coordination with the UNDP and Afghanistan Minister of Justice, the 2014 research provided a basis for the draft law on conciliatory jirgas in civil disputes. And this is now, in fact, by the government law committee. The law was approved, I think, just 2-3 months ago, and is waiting for the parliaments to approve it finally. So, in my view, although I intended that the hybrid model would be fully translated into practice to include both civil disputes and minor criminal offenses, and in that way it would provide more inclusive, accessible, and effective and restorative justice to all Afghans. But its politicization only partially translates the original spirit, if you like, or logic of the hybrid model into practice. It's nevertheless a small step forward. So now to go back to the main topic of Southernising criminology. So, I mentioned earlier, the Afghan state justice system is influenced by the global north, mainly by the French legal system. The hybrid model is indigenization of that French-inspired Afghan law. But more importantly, it is also a contribution to criminological knowledge in the global north. For example, the publication related to the hybrid model were nominated for the 2018 Times Higher Education Awards, and it is a institution of the global north. But also, John Braithwaite and I won the British Journal of Criminology's 2013 Razanovich Prize, and it is a institution of the global north. So, in my view, this actually contributed to the existing body of knowledge in the global north. But more importantly, and which is an issue that has been neglected, especially in the discussion about restorative justice. Of course, most of us have been reading that the roots or origins of modern restorative justice can be traced to communities in the global north, mainly in New Zealand and Canada. But in reality, they're also traceable to jirgas and shuras in Afghanistan. But no one has mentioned this. So I'm going to quote here from my publication with John Braithwaite. And we say that while there is a formidable vernacularization, I hope I can pronounce this word, vernacularization of restorative justice discourse into Afghan thinking, which I mentioned earlier has been imported from the West, about reconciliation and violence prevention, but sadly, little vernacularization of Afghan wisdom into Western restorative justice thinking. Again, Southernising criminology, jirga and shura provides insights into the origin of restorative justice, and yet no one speaks about them. So to go back to Southernising criminology, my views are slightly different. I think I am against the use of decolonizing. I know Biko may be not happy with this decolonizing. Yes, in some contexts, yes, we need decolonization, but in general, criminological knowledge that have been developed in the global north is a huge achievement for the whole of humanity. But what is lacking is bridging this knowledge in our increasingly globalized world to the criminological perspectives, practices, and knowledge that have been developed in the global south. And in my view, the best way to go forward about Southernising criminology is to examine common grounds and to bring and to bridge existing scholarships between the global south and the global north. I think I'm going to stop, and I'm happy to answer your question. There are some references that I've referred to, but I'm happy to share the slides with you. Thank you all for listening.
Thank you so much, Professor Wardak, for such a thought-provoking and informative presentation. I wonder if you will all join me in a virtual round of applause, perhaps turning on your camera if you feel comfortable in doing so. I wondered if anyone would like to start the Q&A session, if anyone has any